So I'll keep that. So much to do, so little time. Let us the Constitution. Welcome, welcome everyone. Beautiful Braze by Bree. Lawful, welcome. Hope everybody is doing well on this Monday. Let's start. Hope everybody is doing well. We're about to start another monumental live. Today we're going to be covering more constitutional drafting. We have some new sections that we are going to be including in the draft that wasn't previously included, so we're going to make sure that we include everything, right? We want accountability, we want transparency, and we want clarity. Clarity as it relates to the law, right? So, the point of these sessions on drafting the Constitution is to ensure that we the people are represented. We the people put together what we consider to be fairness, right? What we have today is, for lack of a better term, problems. And those problems cause us grievances. And it is the culmination of those grievances that cause an outcry. So, what we aim to do is to stop asking. Because we ask by going to the courts, we ask by petition, we ask by lawsuit, and we ask by public outcry. Justice for all. How is my case in the Supreme Court? I don't have a case in the Supreme Court at the moment. Are you referring to Mr. Dunn? I am not Mr. Dunn. Mr. Dunn is handling his case. Yeah, he's handling his case quite well. Yeah, repairing the breach says a lot of their acts are double standards. Exactly. Ricardo, Lawful, welcome. How can we have a system that we trust, but yet still the system only prosecutes those on the outside, or frequently prosecutes those on the outside, but those on the inside, they get leniency, they get all sorts of leeway, and those on the outside suffer? One of the bigger problems that we've had in Jamaica is that access to the courts not only require money, right? Because even if you don't have an attorney and you want to file a case, you have to pay You have to pay money to go and seek justice. Right? And that is ridiculous. Why is this ridiculous? We are the ones who pay taxes to build the courts. We are the one that pay taxes to maintain the courts. We are the one that pays the salaries of all of the employees of the court. So why are we paying for them to work? It just seems contrary to what common sense would dictate. Because if we are the owners, we are the proprietors, we are the ones investing in these resources, but we still have to pay to get access to it? How would that work? There are so many different aspects of problems that we have at varying levels. And instead of complaining, we have to get into the habit of formulating solutions. We have to get into the habit of taking things into our hand, learning the problem, and then taking the necessary action. And in some cases, if a route is not there, we create one. I have a case one, and they told me I need 300,000 for them to start. That sounds like an attorney fee. Yeah, attorney fees, depending on the type of case, it's a lot of money. It's a lot of money for some people, right? And that fee, that initial fee that you need to pay, is a big deterrent to go into court. Because if you don't know what you're doing, you have to pay somebody. So now you have an added fee, an added continuous fee, because you see, the longer the case draw out, the more the attorney is going to want. Right? They're going to bill you based on how much effort it requires to deal with your case. And I find that egregious. Listen, man, there's just so many layers to this that instead of even attempting to try to fix the problems, it makes sense that we embark on a different journey. We come off of the road with the heap of pothole them, and we just start chop out one new part. So we don't deal with the asking. TikTok police, awful, welcome. Then FIFA says, I'm going to traffic court this week for this fog light issue. Yeah, the tickets are another issue for a lot of people. But I plead not guilty. Okay. Well, the thing is, if you are going to challenge a ticket, just make sure, say, you have enough information. So when you go to court, you are the one asking questions. If your innocence is presumed, you should not be answering anything. Right? The Constitution section 16(6)(f) states that you or anyone convicted, or anyone charged with a crime is protected from self-incrimination. Right? So you have to ensure that you protect your right to freedom from self-incrimination. Let me pull that up. The Charter of Fundamental Rights and Freedoms. Actually, no, JA says if it's in the right, it will be thrown out. Some of them are not that easy, It sounds easy, but some of them are not. So 14, should be 16. 15. Section 16, 6, F. What does it say? Every person charged with a criminal offense shall not be compelled to testify against himself or to make any statement amounting to a confession or admission of guilt, and, except with his own consent, not be tried in his absence. I'm going to drop a little gem before we start, Zane. Who ready for the gem before we start? This is a little bit unconventional. Because usually, I wait for the agents them to drop in and start report the live before I drop the gems. Zane? So I'm just going to drop a single gem. So, how many, alright, by typing in the chat, I'm going to ask a question, right? How many of you know what happened when a police constable gives you a ticket? Do you know what that procedure is called? Drop a 1 in the chat if you know, or if you know the answer, you can drop it in the chat. Do you know the procedure, what it's called when a police officer writes a ticket and issues it to you? Let me know. Drop a 1 in the chat, or you can type in the answer if you know what that is. Devon said, don't know. So nobody knows what happens when you get a ticket. That process, that just, all right, I'm going to play out the scenario and I'm going to explain to you why. And I'm going to give you the answer. You see, when you travel down the road in your car and you get stopped, it doesn't matter for what, right? Curious, serve a summons. Not really correct. Sasha Gay says malicious prosecution. Ricardo says an interrupted travel. Let us break it down. Benji Comics say arrest. We don't have the correct answer yet. Right? So, you're traveling down the street. You get stopped by the constable for whatever reason, right? Remember, you know, TikTok police are ultra vires. Remember, if you commit a crime, the constable is supposed to do what? Charge you right away. Them not supposed to ask you no question. That is not how criminal law works. If they're asking you questions, this is why I ask you, what do you think that is? So them stop you, them start ask you questions, then they start tell you what you do from what you not do, and then them start request information from you, right? Typically, driver's license, insurance, sometimes registration, whatever vehicle documents you have, them want to see it, right? So, them stop you. Then they are going through a process of investigation. That is what the questioning is about, right? So first, you are stopped. You know what that initial stop is? That is called detention. It means that you are being held and you are not allowed to go until the constable deem it necessary to allow you free passage. So, you are first stopped and you are detained. Okay? Once you are detained, the constable begins an investigation. And that is the asking of questions, the asking whether or not you please step out of the vehicle. Can we conduct a search? Can you roll down your window? All of those are requests. Those are not lawful orders. Right? So the constable is doing an investigation and he's requesting things of you. Now people get scared, people mind gone all over the place when this is happening. So you now realize, say, I just one man ask a question. That is not a lawful duty for them to be doing on the side of the road. Right? So, when the constable asks you all these questions, you can actually say, I refuse, I object, I do not give permission. If you want the permission, I grant it, and I hereby revoke the permission. You can actually say those things. But anyways, we're not going to stop this up. The questions get asked, and you go through this whole process, and in the end, when the constable done his investigation, that's when he issues you a ticket. It is absolutely very rare that someone is stopped and the constable just goes ahead and issue you a ticket. Very, very rare. All of them chat to you. Them talk. Am I correct? Has anyone ever been stopped and the constable not said nothing to them and just issue them the ticket? If that happened to you, drop a 1 in the chat. All right. So now, remember the question? What is it called when you are issued a ticket? That, my friends, 6 in that case, don't take it. We are not over here. 6, you sound like a law enforcement agent. But just listen, man. This is not here bashing the police. We are simply speaking lawfully over here. Zine? So just be cordial, right? The process that happens when you get stopped up to the point where the police issue you a ticket, that, my friends, is called prosecution on the side of the road. It sounds strange, but all the elements are met. You are suspected of a crime. Did you know that traffic tickets are charges for crimes? Me not have to tell you that. The commissioner don't come out and say that. The chief justice come out and say that. It is also in the Constabulary Force Act. It is also in the Constitution. You should have known that by now. Traffic tickets are considered charges for crimes. Now, when you get stopped, that is suspicion of a crime. When they talk to you and them interview you, that is a part of their investigation. When them ask for you come out of the car, when them ask for you open the trunk, when they ask if you wind down the window, all of them something there. That is a part. That is a part of the criminal prosecution. And at the end, the constable issues a judgment, a written order to pay. That written order to pay is now enforceable inside and outside of court. You see, when you go through the process, but you don't know what's happening. TJ wants to repeat it again. The process by which your freedom of travel is interfered with and you get stopped by a constable on the side of the road. He stand up in the road and him say, over here, so, over here, so. And you proceed to park your car on the side of the road. The constable walks over. That first stopping of your car is called detention. When the constable walks over and he starts to interview you, Do you know how fast you were going? You know say that was speeding. You know say this is an offense. You know say that is an offense. Let me see your driver's license, please. Let me see your vehicle documents, please. And then keep on and my ask and my dig. Where you going? Where you coming from? Why is this light on? Why is this? Why is that? The more you talk, the more you incriminate yourself. So that is called a part of their investigation. And at the end of the investigation, more than likely, the constable writes a ticket. And that ticket is a criminal conviction. And that criminal conviction is now enforceable in two ways. Either you pay the money or you go and you contest the charges. When you go and you are contesting the charges, right? That is an appeal. It is not a civil matter anymore. It starts out as a civil matter which is unlawful. Sabak, lawful, welcome. All traffic tickets, all traffic matters start out as civil matters. Anytime they issue a ticket that has a monetary value, that is a civil matter. Criminal matters do not involve money when it concerns the government. Plain and simple. The Constabulary Force Act Section 13 specifically states, no member of the force shall engage in civil process. So that, like TikTok police just said, is an ultra virus action supposedly being authorized by the Road Traffic Act or the Road Traffic Regulations. Right? So, when you go to court, you cannot counterclaim. That is the strange part. You cannot counterclaim. What you can do is you can challenge, you can appeal, you can contest that judgment. It is not the ticket, you know. It is not necessarily the ticket you are challenging. You are challenging the authority of the constable to have issued that ticket. But you don't know what's going on and nobody is going to tell you. Let us take a look at what the law says. 6 says you also have the right to plea an illegal stop too. We don't talk about pleading over here. But yes, for convenience and for judicial economy, the judge is going to insist that you plea. Guilty or not guilty. That first answer that you give. If you want to know better and do better, you come to class. Right? But for the regular people them out there, for the regular people them out there, you simply would have say, not guilty. Right? But in truth and in fact, there is no such thing as a not guilty plea. Yeah, I'm showing you why. I don't want to see the law that says there is no not guilty plea. So, when the court asks you or when the judge asks you, sir, guilty or not guilty, that is not correct. Exactly, the word plea means to beg. The plea means to pray to a superior authority. So I want to see the law that says a not guilty plea is not valid. There is no such thing as a not guilty plea. Right? I'm going to bring it up right now. Should be section 16.5. Here we go. So, let us take a look. Right? So here we are on the computer. This is the Charter of Fundamental Rights and Freedom, which is the Constitutional Amendment Act 2011. See, we're at section 16. You see? Protection of the right to due process. I don't know what due process is, right? Everybody already know what due process. So we're not going to go over that. All right. 16.5. See 16.5, yeah? You see what it say? Let me zoom it in a little bit. Every person charged with a criminal offense shall be presumed innocent until he is proved guilty or has pled or has pleaded guilty. Right? Can someone show me the word not guilty here, so? Six, I know there is no such thing as guilty with explanation. But yet still, the clerks of court, which is not, there is no such thing as a clerk. There is such thing as a clerk. The clerk of the court is generally outside telling people, you can't tell the judge guilty with explanation and then we hear what you have to say. And they are out there unlawfully giving legal advice to people. Oh, you want to know what due process is? I see a couple of comments about due process, right? What is due process? Let us talk about that. Due process is a specific standard of requirements that needs to be met in order for someone to be charged and tried in court. Let me say that again. A matter of fact, let me not give just my own explanation of it. We're going to pull it up in our dictionary. See it? Let us look at the Oxford Dictionary of Law, 5th edition, right? So we are going to look for the legal definition of the word. I'm not going to explain it to you because I don't want people feel like say me I make up things. Because we only talk about evidence over here. You know, see, because somebody start talking about traffic ticket and don't get me off on this track here. But we soon get back to constitutional drafting. Going to show you what due process means. The legal definition. Right? Alright, make we see if we can scroll down a bit. See. DE DO or DO derivative disable discovery. We soon get there. We're getting there. Drag Drago duty. Alright, so here we go. Due diligence. Alright, we come so far. Let me see something. You know, say the dictionary here. Now have it. Alright. Let us go to the Black's Law Dictionary then. We know say Black's Law have everything. 4th edition. One don't have it, jump over to the next. Alright. Due. How you not say? Okay, due process of law. Here we go. I'm just about to say there is no way. Alright. Here we have the term due process of law. Law in its regular court of administration through courts of justice. Right? Due process of law in each particular case means such an powers of the government as the settled maxims of law permit and sanction, and under such safeguards for the protection of individual rights as those maxims prescribe for the class of cases to which the one in question belongs, right? So, it is basically what is permitted by the government as it regards to the safeguards and the protection of the individual's rights. So in order to protect your rights, there has to be a list of things that is considered to protect the individual from arbitrary judgment or from judgment where people just make up. Right? So, in a FIWI Charter of Fundamental Rights and Freedoms, the right to due process of 12 clauses. You see? Section 16 of the Charter of Fundamental Rights and Freedom. Right? Say, let me show you. Let me zoom in so you can see for yourself. You see, say? Protection of right to due process. And in this section, look what them have. 16.1, 16.2, 16.3, 16.4, 16.5, 16.6, 16.7, 16.8, 16.9, 10, 11, 12. So 12 paragraph. More than 12 paragraphs still. Some paragraph have multiple section. So you have this entire thing. 3 pages. 4. Hold on. I'm going to pass it. I think I'm going to pass it. I think I got 3 pages. 3 pages of things that encompass due process. So if you don't get all of them, something here, you were not given due process. What does it say? What is all of this? It says, 1, whenever any person is charged with a criminal offense, he shall, unless the charge is withdrawn, be afforded a fair hearing within a reasonable time by an independent and impartial court established by law. You know overs what that mean? And I can see it, right? Whenever any person is charged with a criminal offense, a traffic ticket is a criminal offense. It is a charge. That's why you can go to jail if you go to court and you don't, and them find you guilty and you don't pay. It is a criminal offense. He shall, so whenever them charge you, you must, unless the charge is withdrawn, you must be afforded a fair hearing within a reasonable time by an independent and impartial court established by law. Here is one of the big problems. How can the court be independent and impartial if the constable is a part of the government, the court is a part of the government, the judge is a part of the government, the clerk is a part of the government? How are you getting an independent and impartial court established by law? If all of those people are being paid by the government, how can they be independent and impartial? Understand what? So, them fail number 1 already. And we have 12 paragraph. And then can't pass number 1. At the very least, it is bias. We cannot have the same body of government charging us and trying us for the same thing, and they are a party to the case. The government is a party to the case and the government is trying the case. Number 2, in the determination of a person's civil rights and obligations or of any legal proceedings which may result in a decision adverse to his interest, he shall be entitled to a fair hearing. You see how much time they tell us you need to have a fair hearing? In a one, it tells us what? You should be afforded a fair hearing. You see number two, it say you are entitled to a fair hearing within a reasonable time. Again, you see, in a one, it tells you, you should be afforded a fair hearing within a reasonable time. In a two again, then come back and I say the same thing. They might emphasize how important it is. He shall be entitled to a fair hearing within a reasonable time by an independent and impartial court or authority established by law. Now, the other question is, when was the last time you see something named law? I am not talking about acts of parliament. I am not talking about regulations. When was the last time have you seen a statute or some legal document that says it is the law? The title of it says law. Why them not say road traffic law? Why them not say road traffic regulations law? Why them not say justice of the peace law? Section 16.9, can you explain lawful? Let's go down to 16.9. No person who shows that he has been tried by any competent court for a criminal offense and either convicted or acquitted shall again be tried for that offense or for any other criminal offense which he could have been convicted at the trial for that offense, save upon the order of a superior court made in the course of appeal proceedings related to the conviction or acquittal, and no person shall be tried for a criminal offense if he shows that he has been pardoned for that offense, provided that nothing in any law shall be held to be inconsistent with or in contravention of this section by reason only that it authorizes any court to try a member of a defense force for a criminal offense, notwithstanding any trial and conviction or acquittal, etc., etc., etc. What does section 16.9 say? No person who shows that he has been tried by any competent court for a criminal offense and either convicted or acquitted shall again be tried for the offense, for that offense, or for any other criminal offense. Right? King says, if the act of the legislature is consistent with the intent of the Constitution, it is law. I did not ask that question, and that is erroneous. Regardless of the current procedural framework that is in place, that is false. I said, can you point to any evidence in a document that says it is law? I am not talking about the interpretation or the intent of it. Because intent can only be had from the original writers. Someone reading something cannot tell the writer's intent. That is garbage. That is something adopted by the court and has been used against people where the law did not prescribe such. We are talking about evidence. We're not talking about procedure. Right, the Constitution is the supreme law of the land. And here we're looking at evidence. We're not talking about procedure. Can you not take the ticket? It doesn't matter whether you take the ticket or not. It has been recorded in an electronic system. In most cases. So, if you refuse the ticket, and you take your things and you drive off, the ticket is still going to be in the system. So I do not suggest anybody do that. That is not going to do anything for the ticket. But what does 16.9 mean? It means that, you see? We don't want to go too far off tangent, you know. But it is saying here, if you have been charged and you have been convicted or acquitted, for example, speeding, Example, speeding. If you get a speeding ticket, right? If you pay that ticket, you have forfeited all your rights. If you challenge the ticket, here is the thing now. In traffic courts, the judges typically do not want to give you a written judgment, regardless of whether or not them find you guilty or not. So, in order for you to even prove that you were charged already with speeding, you're going to have to go through a process to try to even get the judgment from the court. Typically, then just send you go pay. Or then tell us that the case throw out. They seldom want to write down anything unless you tell them you are going to appeal the case to the Court of Appeals. So this in and of itself, if you are to challenge a ticket on the basis that you already got a speeding ticket, the first thing the judge is going to say, well, sir, this is a different speeding ticket and this is a different place. This is a different charge. So even though the Constitution did not say it has to be a different charge, right here it says you shall not be again tried for that offense. Right? They're going to use this part and say, well, it means that each individual offense is that offense. Or for any other criminal offense which he could have been convicted at the trial. Now, when you got the ticket, did you have a trial? How can you be issued a judgment without a trial? Because the ticket itself is a judgment. Yes, traffic court will tell you. You cannot leave the court without paying. What are you talking about? Without any evidence that you have been to court, they will direct you to go to the whatever window to go pay. You can't leave the court and not pay. Anyways, section 16(9) is supposed to protect you from double jeopardy. You are not supposed to be convicted of the same crime twice or more times. So speeding, you are not supposed to be convicted of speeding again. But again, the interpretation of the court, this is going to be a difficult battle if you take this position. So, there are many parts of due process that you can contend. For those of you who have not come to class, I do not recommend you go all the way down here, so trying to use 16(9) for any reason, because it is difficult to argue that. Anyways, so as you can see, whole heap of something in a due process that you can use. And on top of that, if you don't know the rights that you have, they will be trampled upon. Make no mistake, your ignorance, you're going to pay for it. And many people, they just run go pay the ticket because them no want to go to court, them no want to waste no time. That is the reason why you continue to get tickets. The court don't have it too easy. King says, just say you don't know which right prevents government overreach. Whenever you type in another comment, what you need to do is just tell me the section of law that you're referring to. So if you're not coming with a section of law that you would like to discuss, then I don't think I am going to address any more of your comments because you are just distracting at this point. So let us proceed with the constitutional draft because we already went in 43 minutes. and we're not touch a draft yet. So can plead not guilty with explanation. If you plead not guilty, they are going to say that you are challenging the ticket and they are going to set a trial date. The first day you go to court, they are not going to do anything. They are just going to set a trial date. That is called your arraignment day, which they won't tell you. As a part of criminal law, the first day is where they determine whether or not they are going to build the case against you or whether you are going to plead. All right. So, and for those of you, 16.5, right? Last explanation on this specific section. The Charter of Fundamental Rights and Freedom, section 16.5, says, every person charged with a criminal offense shall be presumed innocent until he is proved guilty or has pleaded guilty. So when you go to court and the judge is forcing you to make a plea, even though you said, Judge, I am here under my presumed innocent under the Charter of Fundamental Rights and Freedoms. And he's going to say, well, sir, if you don't plead, then I will have to enter a plea on your behalf. And I am going to take it that you are challenging the matter. And therefore, I'm going to enter a not guilty plea on your behalf. Right? That is what they're going to do. Because ultimately, they're not going to argue with you all day. They're going to try to explain that a not guilty does not mean that you are giving up any right or that you are testifying against yourself and all them something that. Right? But that is not what the Constitution says. That is not what the Charter of Fundamental Rights and Freedom says. It says you are presumed innocent. Right? So unless you decide that you're going to plead guilty, they have to prove. You say, until he is proved guilty. He never said them ask you. He say, once you challenge it, once you presume your innocence, once you invoke your innocence, them have to prove say you're guilty. You're not supposed to take part in none of them games. So you're not supposed to be pleading unless you are pleading guilty. That's it. Zin? All right. So, that is that. Now, let us head over to our constitutional draft. And for those who are new, how do you get to the draft? First, you go to voiceofjamaica.com. If you want to see a copy of it, if you want to review it on your own time, you first go to voiceofjamaica.com and you scroll down and the first post says New Constitution. Right, you hit that one and here you have the constitutional draft in PDF form, in Word form, and you also have the Declaration of Independence. Right? So we're going to go over the constitutional draft and I'm going to show you the additional sections that we've incorporated that are necessary. Some of these sections are also derived. Let me show you. If you scroll down on the same page where you can download the draft, you will notice the suggestions here. We have quite a few suggestions now. People are submitting suggestions. So if you want to submit a suggestion, you can enter your suggestion here in the box and hit submit. You don't have to put in your email address or any contact information. You just put your name, you put in the suggestion that you have, and you submit, right? When the suggestions are received, they are going to be posted on the website like this. So we block out the details so you remain somewhat anonymous, right? And for those who want to see what we talked about before in the previous live streams, here are the replays under the suggestions, right? So you can go back and see all that we have discussed while we build this new constitutional draft. All right, so first question many people have is, why is Jamaica spelled like this? And I have to keep going over this because I get this question even in my messages. Jamaica is spelled like this because we do not want to infringe on the current copyright. The current name that is being used as the spelling of Jamaica is copywritten. It is a trademark of the British. So this is how we are spelling it in this constitution. Right? As we scroll down, you'll notice a table of contents. Now this is again a work in progress, but this is what is currently in place thus far, and it is going to expand as we include other sections of law. Because what we're doing here is we're encompassing the law itself, all of the things that are prohibited and also allowed in the Constitution itself, right? So the Constitution will serve as the sole body of law going forward. So now, if we go all the way down, we're going to continue where we left off. Let me see what page we were at, the last one. Protection of property, 158. So from 159, 158. So civil procedure and administration of justice. So this is the procedure, right? And there are a few more things that are going to be added to the Constitution, including forms and certain documents that may be necessary for everyone to access. So if you are to go to court for whatever reason, or you're supposed to craft a legal document, some of these basic documents are going to be included in the Constitution itself. So you have a template to work from. You have something you can go by. And believe it or not, let me show you something. Even when you go to, like, I think this has it as well. Let me see. Bah. A lot of the acts of parliament, many of you might not realize, but they actually have some forms inside the document. I don't remember seeing one in the Constabulary Force Act. But like the Road Traffic Act and some of these other documents, they do have forms and different templates that are supposed to be used by the public officials, which many times they don't use it, right? So this is the civil procedure and administration of justice. And these sections from 166 to 190 were added since the last section that we closed off on, which was property. And you're going to find some of this rather interesting. And again, if you see something that you'd like to add, you can actually come up. Let me see, I have somebody that want to come up. Rick, then I'm gonna bring you up. All right, look like you're gone. All right, so if you have suggestions, you can actually bring them up on the live, or you can submit them through voiceofjamaica.com under the new constitution link. All right, purpose. So, purpose. Civil procedure shall provide a fair, timely, and transparent system for resolving disputes. All proceedings shall aim to secure justice, efficiency, and equal treatment under law. Access to courts. Every person has the right to bring a civil claim before a court of law. No person shall be denied access to justice due to status, identity, or condition. Courts shall be open and accessible to the public except where limited by law. For example, as we said, there are certain cases, like family matter cases, like, certain high-profile cases, there may be limited restrictions, right? like limiting the names, certain personal details would be redacted or shortened for privacy. But that is the only real exception where you would have limited access to the courts, right? Commencement of proceedings. Civil proceedings shall begin by a clear written claim stating the parties, the issue or question to be decided by the court, the facts relied upon, the relief sought. The claim must be filed and recorded in the court's public registry, right? And it is a shame in today's day and age that we still have to be going to a window, going to a clerk to be submitting documents. We should not even be going to a courthouse to be filing a claim, right? We should simply be able to file the claim on the computer. You scan it into the computer and you file the claim. When the case is called, you have to bring your originals. It's that simple. We should not be having to go down to no courthouse to go file no claim. In this day and age, that is ridiculous. Right? Does the Constitution provide for an Attorney General to represent the interests of the people? Well, that is not what such an office would be called, but yes, there will be a prosecuting authority, that will have delegates that they will use to prosecute criminal matters. Service of process. A defendant must be given proper notice by service of a court-issued summons, complaint, and any initial documents of any claim against them. Service shall be direct and verifiable, or by lawful alternative means where necessary. Service by courier/mail with signature delivery shall be deemed sufficient. Right? So this whole thing about finding a process server and all of them, something there. Yes, it is still valid, but a simple mailing somebody with signature delivery should be sufficient to constitute service. Because if you have signed feet and I you that, you get served. Simple. 3. Judgment shall be entered. No judgment shall be entered without proof of service. This presumption that the courts used to say, well, if you did not object to it or, this wasn't a problem for you, then we're not going to impose a requirement to show that service was perfected. Foolishness. No judgment shall be entered without proof of service. So when you reach a court, you have to show, say, you serve the individual, or else the case gets thrown out. Right to be heard. Every party has the right to present their case fully. Each party shall have the opportunity to respond to claims, present evidence, and challenge opposing evidence. No decision shall be made without giving each party a fair opportunity to be heard. Right? So the judge can't tell us that them no want to hear that, or they no want to hear what you have to say. You always have the chance to present your full evidence and your full case. And once you're done, then everything is closed off and the the tribunal makes their decision. Alright? Equality of the parties. All parties shall be equal before the court. No party shall receive advantage based on position, office, or influence. Evidence. Decisions shall be based on relevant, reliable, and lawfully obtained evidence. Evidence must be disclosed to all parties at least 30 days prior to the final hearing if it is to be relied upon in court. Very simple. Somebody can just bring up something in a court and I ask you if you have any objection to it. You need to have proper notice in every single stage of a court case. Secret, surprise, or undisclosed evidence shall not be used to determine a matter. Burden and standard of proof. The party bringing a claim bears the burden of proving it. Civil matters shall be determined on the balance of probabilities unless otherwise provided by law. The balance of probabilities is the standard of proof in civil cases, requiring that a claim is more likely than not to be true or over 50% probable. Judicial duty. The court shall remain impartial at all times. The court shall apply the law as written in this Constitution, ensure fairness in proceedings, prevent abuse of process, avoid the use of judicial discretion, rely on any previous rulings. Now, this is a very important one. Where can I get a copy of what you're reading, bro? To get a copy, you go to voiceofjamaica.com. Hold on. Go to voiceofjamaica.com. Once you see this logo, you know you're in the right place. You scroll down. And the first post, it says New Constitution. So you click on that. And here you have the PDF edition. You also have the Word edition. And you can review it from there. You also have the Declaration of Independence, which is probably the first one you should read. Right? But we're going through the constitutional draft now. So, a lot of the times, yeah man, you're most welcome. A lot of the times we have cases that are being decided. And these cases are not being decided on their own evidence and facts. They are being decided based on previous cases, not based on the actual law. And that is a problem for most people. You can use other cases as persuasive evidence, but the court cannot rely upon previous rulings in the cases that are brought before it. And that is where the court is using common law instead of using the actual law to determine a case. Regardless of if it is monotonous or if it is repetitive. If you don't want to be a judge, you simply get up and go look at next profession. Everyone who bring a case into court, it should be determined as it relates to the law, not based on no previous rulings. How can you say you're fair and impartial if you're going to use a different foundation of law? Previous cases, common law, talking about, in 1930s, this was ruled upon in this way and in that way. No, that is judicial influence. That is now a body of law that is not supported by the Constitution. So anyways, we're not going to get too deep into that, but yeah, we need to get rid of this whole common law thing. Every case we bring into the court is supposed to be determined as it relates to the law and the facts of that case. Point blank. You're not supposed to have reference to other cases. Any judicial act beyond lawful authority is void. Timeliness. Proceedings shall be conducted without unnecessary delay. Now, this section is going to be expanded because we need to set specific time frames for the court to complete matters. We cannot have cases being dragged out 2, 3, 4, 5, 15 years. That is ridiculous. So we need to set specific times within the timeliness section. 2, courts shall enforce reasonable timeliness for each stage of a case. Remedies. Courts may grant lawful remedies including compensation, restitution, injunction, declaratory relief, writ or order of mandamus or prohibition based on petition and evidence. Now, I know many people don't know what a writ or a mandamus or prohibition is, right? These are orders from the court. I guess you can say mandating or forcing a public official or a corporation or an agent of some sort to do something or stop doing something. I'm a part of a case going on 16 years now. That is terrible. 16 years, one case? Jaja. 2, remedies shall be proportionate and direct at resolving the dispute. Remedies shall not include anything not requested as a relief by either party. And this is also important. If a party is requesting a certain remedy and the court determines that, yes, that party is entitled to that remedy, the court cannot now then say, and we're going to award this. If the party did not request a remedy, the court does not have any authority to go beyond that request and say, well, we can also give this remedy as well. Right? 4. Where a claim is brought with malice, ill will, or bad faith, the case shall be dismissed, and the court may order punishment in proportion to the severity of the evidence before it. So if somebody bring a false claim to the court can dismiss the claim and punish the individual for bringing up that false claim. You know, some people just sue people because of some kind of malice or some kind of whatever them have bad mind. Yeah. Punishment need for today for them kind of foolishness there. Where a claim is brought and the accused is proven innocent, the defendant shall be entitled to seek relief within the same action for any damage sustained as a result of the suit. This is another word for civil malicious prosecution, right? If somebody bring a claim and the defendant is proven innocent, that means that the claimant was lying in the first place, right? So the defendant can seek relief. You know, the amount of time they have to come to court, you know, whatever expenses them have and all them something there. Yeah, them something they have to get paid. So this will also reduce the claims being brought to the court, you know, in a ridiculous manner. Like people not have consequences. That's why them have bring certain things to court. If we start give penalties for people who are bring case to court and no say a foolishness them are bring come to court, then we stop of all of these ridiculous cases. If you're not sure with the evidence where you have, say somebody do something, you put it in your pocket. Keep it moving. 12. Costs. Costs, including attorney fees, may be awarded in accordance with law. The court shall consider fairness, conduct, and necessity when awarding costs. Review and appeal. A party has the right to seek review or appeal of a decision. Appeals shall only be based on error of law, procedural unfairness, or significant error of fact. Alright, so you can appeal all you want, but it has to be based on one of these three. Enforcement of judgments. Judgments of the court shall be binding and enforceable. Enforcement shall be carried out lawfully and without abuse. Violations of a court order shall be subject to further civil penalties. Right? So you know, sometimes you have the court issue a judgment and then the party who is supposed to pay or the party who is supposed to perform, they don't perform. Them delay, them lag, them come with excuse and all kind of something. You can go back to the court and get even more civil penalties instituted against somebody like that, even if it's the government. If you are supposed to get remedy, there is not supposed to be any delay in getting a remedy. Public record. All proceedings shall be recorded, and we talk about this in other previous sections. Records shall be accurate, accessible, preserved for review. Right? So every single thing that is said in the court, you have video recording, you have audio recording, and we're going to have a section for a stenographer, right? Someone who type up all of the proceedings, everything that is said, all the breaks that are had. It doesn't matter what somebody mean, it is being recorded, right? And the principle of this section is the civil procedure shall ensure fairness, transparency, accountability, equal access to justice, and resolution of disputes according to law. Imagine we're in 2026 and we still can't have electronic records of proceedings and also at least audio recordings of the proceedings. The parish court then never want to give you the piece of paper for say you get convicted or you get acquitted of the charge or whatever it is. Anyways, here we have the criminal procedure and administration of justice. So this is the criminal code. Criminal procedure code. Criminal procedure shall ensure fair, impartial, and lawful determination of alleged crimes. Proceedings shall protect the rights of the accused, the interest of justice, and the safety of society. Presumption of innocence. Every person charged with a crime is presumed innocent until proven guilty. We just talked about that just now. But now we need to give it some teeth. No person shall be treated as guilty before lawful conviction. Lawful charge. No person shall be charged except under a law clearly defining the crime. The charge must state the alleged act, the law violated, sufficient detail to prepare a defense, the evidence, if any, used in connection with the charge. Arrest and detention. No person shall be arrested or detained by any law enforcement officer except upon witnessing a crime, upon reasonable suspicion of a crime, or under lawful warrant. The person accused shall be informed promptly of the reason for the arrest, including the law that is violated, their rights under law. There shall be no detention without charge of a crime, and any such detention shall be limited in time and subject to judicial review within 3 hours of arrest. I can read a part there again. There shall be no detention without charge of a crime. You know how sometimes the police then just go lock up some people and tell them, say them and hold them so that them can do some investigation? That changes here. There shall be no detention without charge of a crime. And any such detention shall be limited in time and subject to judicial review within 3 hours of arrest. So nobody not supposed to sit down in a cell for days and weeks and wait for no judge. A pool of judges shall be available in person or by remote video conference to review all arrests and make record of the account of the details of the arrest and determine, according to law, if detention is required to secure the accused or require surety to secure his trial. Does that make sense, people? Instead of locking up people, and I tell them say they need to wait for go see one judge, isn't it more practical to have one or two judge in the parish, where if a police is going to arrest somebody, it is immediately reviewed by a judge? Because we all know sometimes we have some arbitrary things that go on a road. See? No person shall be held in detention prior to trial unless a serious crime is charged with evidence supporting the allegation of either unaliving or attempted unaliving, robbery, rape, intentional public disturbance, or domestic violence. Right? So that means, unless it is a serious matter, nobody not supposed to be detained and in a holding cell for no reason. In all such cases described in paragraph 5, trial shall commence within 45 days of the decision of detainment. At the request of the accused, a speedy trial is a procedural right that may be invoked, allowing for 14 days to prosecute the charge. We're not supposed to wait months. Nobody not supposed to wait months for no trial. That is ridiculous. Right to counsel. Every accused person has the right to legal representation of their own choosing or by a state-provided representative. Where a person accused of a crime cannot secure counsel, provision shall be made to ensure representation unless waived by the accused in writing. So if you don't want an attorney, you have to write and sign to that. Counsel representation shall be voluntary, regardless of the seriousness of the charge. So if you decide, say, you don't want nobody represent you, and you are innocent, and whatever the case may be, you have that right. Right? But again, it may be to your benefit, it may be to your detriment. But if we, the people, provide legal representation for people, there's really no need to be going that route. But hey, you have that choice. That's your right. Right to silence. No person shall be compelled to testify against themselves. Silence shall not be taken as evidence of guilt. Disclosure. The prosecution shall disclose all evidence intended to be used and that may assist the defense. That is based on witness statements or affidavits. No conviction shall be based on undisclosed evidence. Fair hearing. Every accused person has the right to a fair and public hearing before an impartial court. Proceedings shall allow presentation of evidence, examination and cross-examination of witnesses, and full defense. Burden and standard of proof. The burden of proof rests on the prosecution. Guilt must be proven beyond reasonable doubt. Evidence shall be required in all criminal cases. Unless impossible, all witnesses shall be required to attend court. Unless impossible, all affidavits shall be accompanied by an oath under penalty of perjury and consequence. Right? So you can't just have somebody submit an affidavit and they are not held accountable if it is proven to be false, right, or tied to a conspiracy. Protection against double jeopardy. No person shall be tried or punished more than once for the same crime after final judgment. New evidence shall not be a precursor or reason to bring a new claim for the same crime, nor allow for the reopening of a case after final judgment. Protection from arbitrary punishment. No person shall be punished or convicted except in accordance with law. Penalties must be proportionate to the crime. Search and seizure. No search or seizure shall occur except under lawful warrant, under clearly defined lawful exception, or under clearly defined lawful exception. Evidence obtained unlawfully shall not be used in court. No court or judge shall authorize a search warrant without evidence or relevant information pertinent to the individual and or place requiring the search. All search warrants and seizures are subject to judicial review with or without the application of the property owner. Trial without delay. Every accused person has the right to be tried within a reasonable time. Unjustified delay may result in dismissal or other remedy. Judgment. Judgments shall be reasoned based on evidence and law. Convictions must clearly state the basis of guilt. Right to appeal. A convicted person has the right to appeal. Appeals may address errors of law, procedural unfairness, miscarriage of justice. Protection from abuse of authority. Any official or agent of the state who fabricates evidence, withholds material evidence, acts outside lawful authority, shall be subject to legal accountability by criminal trial. Right? So all, as we discussed before, all immunity is out the window. If you break the law, you are subject to criminal trial. Enforcement. Courts shall ensure compliance with this article. Violations may result in exclusion of evidence, dismissal of charges, and legal action against responsible parties. Right? Criminal procedure shall ensure justice, fairness, protection of the innocent, accountability of authority, and lawful determination of guilt. Right? The whole point of the criminal procedure is to ensure that everybody knows say, if you're not in the right, you basically are go down the path of a criminal trial. Right? Now here is an interesting one that many people may not have even heard of before. This is the Code of Judicial Conduct and Limits of Judicial Authority. So this gives us the rules that the judges have to follow. Source of judicial authority. All judicial authority derives solely from this Constitution and laws enacted under it. No judge shall exercise authority beyond what is expressly provided by law. Right? In our current society, can the individual who is in prison already, can they use this right when it come out? If it is not a crime under this Constitution, then yes, it can be challenged. It is subject to judicial review. Right? So, in our current society, judges, most people know that judges have judicial immunity. Right? It means that they cannot be held liable for anything they say or do, including wrongful judgments, bias, and all of them something there. Now, they can be removed from the bench and they can be punished by an oversight authority. But you as an individual, when you get a judgment from that judge, it is not going to be removed or reversed simply because, the judge was punished. Now, here we have an express section of law that is stating that a judge cannot exercise authority beyond what is expressly provided by law. And what this means is that we are now criminalizing actions that are taken by a judge or a tribunal that is clearly outside of the law. Right now, if a judge rules outside of the law, they don't really have much of a penalty, They might get a warning or they might get a review strike or something. But they don't have any penalties like the civilians that they are judging, have penalties. They don't have those penalties. So we are removing all of that leverage where they can just rule with an iron fist and tell you what to do and take away your rights and tell us you have to plead and you have to do this and you have to do that when it is not in law. Right? So they can exercise authority beyond what is expressly provided by law. Duty to apply law. Judges shall apply the law as written. Interpretation shall be based on the plain meaning of the text. Clear legislative intent were expressed in the text. And we were talking about this on the previous live. We cannot have judges that are creating law. They are ruling on something saying, well, we don't think Parliament intended this. Well, we think Parliament intended this word and this sentence to mean this. It is very simple. If you don't know what Parliament mean, you send them a communication and ask them to clarify. You don't come up with your own interpretation of what you think they mean. That means that you are now blurring the barrier of separation of powers. You are now exercising lawmaking authority, which is again unlawful because that is not provided for in the Constitution or anything else. Right? Judges shall not create, modify, nor extend law, nor the meaning of the text, nor add interpretation that does not exist in the plain reading of the text. Right? So we have to clarify all of this. Prohibition of arbitrary decision making. No decision shall be based on personal belief, policy preference, subjective discretion. Every decision must be grounded in established law, proven facts, and supporting evidence. Right? So we are removing judicial discretion altogether. You can't come up with your own thing and I say a law. You can't determine a case based on your feelings. Elimination of unbounded discretion. Judicial discretion shall not be exercised except where expressly authorized by statute and limited by clear standards. Where discretion is permitted, it must be reasoned, be consistent, and be reviewable. So if there is such a thing that is judicial discretion, it has to be stated in the law. What about judge or chief judge owning a court? That abolished from day one. From day one, all courts are supposed to be owned by the people, by the public. No private individual can own a court, especially if you're working there. Conflict of interest. Straight to jail. No, sir. Section 5. Rejection of unwritten law. Courts shall not rely on unwritten law, custom, or tradition as a source of authority. Common law shall have no force unless A. It is codified into statute, or B. Expressly incorporated in this constitution, which is the same thing. Requirements of reasoned judgments. Every judicial decision shall state the applicable law, identify the facts and or supporting evidence relied upon, explain the application of the law to facts, right? And conclusions without reasoning are void. Everything has to be written down. Everything. It doesn't matter how small or simple the case is. We have to see the reasoning and what the judge ruled. Equality before the law. Judges shall treat all parties equally. No preference shall be given based on status, position, or affiliation. Duty of impartiality. Judges shall remain neutral and independent. A judge shall not favor any party, engage in ex parte influence nor communication. Right? Any conflict of interest shall require recusal, meaning you remove yourself from the case. Conflict of interest includes affiliation, connection, or relation to the parties or the facts of a case. Right? So if you have anything at all that connects you to a case, that judge needs to remove himself or herself. Adherence to procedure. Judges shall strictly follow lawful procedures. No judge shall bypass procedural requirements, admit nor consider unlawful evidence, or deny a party the right to be heard. You know, sometimes we hear judges, I tell people say, "Me don't want to hear you talk right now." Or "You can't talk in my court. You need to be quiet." Them something they're abolished. The courts are for the people. The courts are paid for by the people. So you can't tell nobody say they can't talk and then cannot be heard. Madness. Limitation on judicial orders. Orders shall not exceed the claims presented, the authority granted by law. Right? So if somebody bring a claim, you cannot make an order expressly outside of what somebody will bring to the court. Ultra vires orders are void, meaning any order outside of the lawful jurisdiction or authority, or outside of the claim, that is a void order. Accountability. Judges are accountable for violations of this constitution. Violations include acting outside lawful authority, issuing arbitrary decisions, failing to apply the law as written. Violations shall result in one or more penalties, including removal from office, legal liability where applicable, criminal prosecution where any ruling resulted in criminal penalties, and permanent ban from the practice of judicial office. Right? So if you are found guilty of a violation of your office as a judge, one of the penalties is not only removal, but you are banned from practicing as a judge further. Right? So you basically get panelist. 12. Transparency. All judicial proceedings and decisions shall be recorded. Records shall be accurate, accessible for review, and preserved. Review and correction. Judicial decisions shall be subject to review. Any decision found to violate this article shall be reversed, corrected, or declared void. A judgment found to be void may not be saved nor upheld in part by reason of any separation of facts, acts, nor evidence. Right? So if we have corruption in a judgment, the entire judgment gone. It is just void. Oath of office. Every judge shall take an oath and swear to uphold this Constitution, apply the law as written, refrain from arbitrary action, and maintain respect and dignity of the court and the parties, rule in confidence of public order and justice. The principle is judicial authority shall ensure strict adherence to law, elimination of arbitrary power, transparency and accountability, and equal justice for all. And the only way we can have that is if we limit all of these powers. Mandatory separation of powers. Government authority shall be divided into 3 distinct branches, the same like we have now: legislative, executive, and judicial. Each branch shall operate independently within its defined powers. Executive functions. Legislative power shall be limited to creating drafts of rules of law based on public submission. So now we are limiting their power to only what is submitted to them to create drafts. This is supposed to be B. Creating rules of public policy based on institutional need. So, if we need a hospital policy, if we need a taxi policy, if we need whatever public policy we need, that is the legislative power that they are going to be using to create these rules that are going to be voted on by the public. Executive power shall be limited to implementing and enforcing laws and public policy, administering public affairs. Judicial power shall be limited to interpreting and applying laws and resolving disputes according to law. Prohibition of power overlap. No branch shall exercise the powers or duty of another. Any act performed outside the lawful function of a branch is void. No branch shall influence or interfere with the powers or duty of another. Non-delegation of core authority. No branch shall transfer its core constitutional powers to another branch or entity. Delegation of administrative functions must be expressly authorized by law and remain subject to oversight. Core powers shall not be delegated under any circumstances. So that means, if we have one part of or one arm of the government telling another arm of the government to go do something that is unlawful, right? You can make a recommendation, you can make a suggestion, but you cannot direct one arm of the government to do something without the assent of the people. Separation of personnel. No person shall simultaneously hold office in more than one branch. Any appointment in violation of this section is void, right? So you can't hold 2 offices at the same time. And we see that in the Constabulary Force Act and we see that in the Road Traffic Act, right? We have these officials exercising more than one authority. How can you be an officer and a constable at the same time, right? And you just choose which hat you are going to wear today or which hat you are going to wear right now. It don't make any sense. Independence of branches. Each branch shall operate free from control, direction, or interference by another. No branch shall direct the decisions of another or control the internal processes of another. Clerks and accountability. Each branch shall be subject to constitutional limits and review. Legislative acts shall be subject to judicial review for compliance with this constitution. Oh, this is checks and accountability. Executive actions shall be subject to judicial review for legality. Judicial conduct shall be subject to lawful review and accountability procedures. Now, for those of you who have been a part of the other drafting lives, you'll be aware that there is a completely independent body that is not tied to any agency, that their job is simply investigation and oversight. Them can go into anywhere at any time without notice, and then can go dig up, and then can go look on procedure, then can go check all of the policies and procedures that are in place in any arm of the government, right? And when they're done, make them report. They can now submit that report to any kind of enforcement agency so that they can take appropriate action, right? So that way, we don't have one arm of the government influencing the other. Prohibition of consolidation of power. No law, rule, policy, or action shall concentrate powers of multiple branches into one body. So you can't have all three bodies of government working together. That is a dangerous combination. So they cannot concentrate their power. They have to remain separate at all times, right? They cannot create authority not accountable to this constitution. So they can't create one next office and say, well, this is not a part of the constitution, so therefore this is not accountable to the constitution. False. You cannot create no authority that is not accountable to this constitution. Any attempt to consolidate power is unconstitutional and void. Collaboration in stages shall be independent in power and execution of duty. So where you have stages of any kind of process, it still has to be independent. One arm of the government can't tell the other part how to do their job. Financial independence. Each branch shall have sufficient and independent resources to perform its functions. Funding shall not be used as a means of control over another. There shall be no excess fund beyond projected estimates each year. All spending, salaries, contractual payments, and other financial obligations shall first be recorded as an expense prior to authorization and distribution. Right? Basic accounting. You charge, then you pay. Transparency and boundaries. The powers and limits of each branch shall be clearly defined, publicly accessible. Any expansion of authority beyond defined limits is prohibited. And when we say prohibited, it simply means it's a violation of the Constitution. If you not follow the law, it is prohibited. Enforcement. Any person or entity within Jamaica may challenge violations of this article. Courts shall declare unlawful acts void, declare corrective action, institute appropriate penalties and sanctions for each violation on its own motion, if not brought forward by a party, recommend investigation and prosecution of suspected or known violations. All right? So if it is brought to the attention of the court that there is a violation going on, and the court has evidence to show that, it is the duty of the court to recommend investigation and prosecution of suspected or known violations. All right? Officials responsible for violations shall be subject to removal and legal accountability, including criminal prosecution. Right? And the principle under separation of powers ensures prevention of tyranny, accountability of government, protection of rights, and lawful balanced governance. Right? I think this is the last one. Qualification, ascension, and certification of public officials. So this one is an interesting one. Purpose. This article establishes mandatory standards for qualification, training, certification, and lawful assumption of office. No person shall exercise public authority without full compliance with this article. Eligibility for office. A person is eligible for public office only if they are a citizen of Jamaica, meet minimum age requirements as defined by law, possess good character and no disqualifying criminal conviction, and demonstrate competency relevant to the office sought. Right? Required education. Every candidate for public office shall complete foundational education in the Constitution of Jamaica, the structure of government, rights and duties of persons, and lawful limits of authority. Additional education specific to the office shall be required where applicable. Right? So, these are the basics. When we talk about, they need to know what they're doing. Mandatory training. Prior to assuming office, each candidate shall complete certified training, including constitutional application in practice, procedural law relevant to the office, ethics and public accountability, limits on authority and abuse prevention. Training shall be standardized and publicly documented. So if we are going to have people assuming office, right? We have people that are of great integrity. We have to make sure, say, they can't cry foul later, they can't say them never know. So just like how the police have to go to school, the same way everybody have to pass training. We have to ensure that everybody know what they do. So if we find any kind of corruption, it is intentional. Right? Constitutional knowledge examination. Every candidate must pass a formal examination demonstrating knowledge of the Constitution, separation of powers, civil and criminal procedure, rights and protections of persons. The examination shall be objective, recorded, and publicly verifiable in outcome. Failure to pass shall prohibit ascension to office. Meaning, if you can't pass the test, you cannot go into office. Certification of qualification. Upon successful completion of education, training, and examination, the candidate shall be deemed qualified for office. Qualification shall be recorded in the public record system prior to appointment or election. Oath to the people. Before assuming office, the candidate shall take a binding oath to the people of Jamaica. The oath shall affirm loyalty to the Constitution, service to the people, adherence to lawful authority, and rejection of corruption and abuse of power. Form of oath. The oath shall state, and here is an example. I, name, do solemnly affirm that I will uphold and defend the Constitution of Jamaica, that I will exercise the authority of my office only as granted by law, that I will act in service to the people with honesty, accountability, and fairness, that I will not exceed my lawful authority, and that I will protect the rights and freedoms of all persons. Any prior allegiance by oath is hereby abandoned and cancelled. This I affirm without reservation. Right? So just in case them have any other oath in place, or them take any other oath prior to ascension to office, they are clearly abandoning the previous oaths. Right? So we don't have double allegiance where you have secret people in a secret places doing secret things. Issuance of certificate of office. Upon completion of the oath, a certificate of public office shall be issued. The certificate shall be issued by the parish commander under seal. The certificate shall include, on the front, the name of the official, the title and capacity of office, the date of issuance, and the official seal. On the back, the full oath text, the signature of the official, and the witnessing authority. Right? So you can't say you don't even remember what kind of oath you did take and what it say. You're going to have a copy of it. Digital record. A digital version of the certificate shall be created at the time of issuance, stored in a secure, read-only database. The database shall form part of the official public record system, be accessible for verification, and prevent alteration or deletion of records. Public verification. The status of any public official shall be verifiable by the public. No person shall act as a public official without a valid certificate and a recorded oath. Invalid ascension. Any person who assumes office without complying with this article holds no lawful authority, and all actions are void. Such conduct shall be subject to legal consequences, whether civil or criminal or both. Continuing obligation. Public officials shall remain bound by their oath at all times. Violation of the oath shall result in removal from office and legal accountability. And the principle here is the public office shall require qualification, knowledge of the Constitution, lawful certification, accountability to the people, transparent and verifiable authority. Right? So that way, nobody can say they never know. They were not taught. They were not informed. Everything requires not only training and education, but proper review using a test-based system. So it tests your knowledge from where you learn and where you know. So if you don't pass, you simply don't get to that office. Right? So we did not go over some property rights as it regards to protection of the property, right? There are people asking about what about when animals enter your property and what is going to happen in those scenarios and things like that. What if somebody trespass on your property, etc., etc. So we're going to go over that part because this is also a new section. So this is protection of property and land. Right to property. Every person has the right to acquire, hold, and use and protect lawful property. Property shall not be interfered with except by law and with due process. Exclusive possession. The lawful occupant or owner of property has the exclusive right to control access to that property. No person shall enter or remain upon property without permission or lawful authority. Brooks, lawful, welcome. Protection against trespass. Entry onto enclosed, fenced, or clearly marked property without consent constitutes trespass. Damien, lawful greetings, welcome. Protection from damage. No person or animal shall damage, interfere with, or remove property belonging to another. Any person or their animal who causes damage shall be liable for repair, restoration, or fair compensation. Protection from animals. Owners or keepers of animals are responsible for preventing those animals from entering or damaging the property of others. Where animals enter enclosed or protected property and cause harm or damage, the responsible party who owns such animal shall be liable under law. Right to secure property. Each person has the right to enclose, fence, or otherwise secure their property. Lawful barriers and notices shall be recognized as clear expressions of non-consent to entry. Security systems capturing picture or video footage shall be treated with priority in any claims arising from suit related to property damage or animal execution. Defense of property. A person may take reasonable and lawful action to prevent trespass or damage to their property. Any action taken must be proportionate and not exceed what is necessary to stop the interference, right? Defensive action in relation to animals. Before any action can be taken in regards to unwanted animals on property, evidence must exist to substantiate future action. Therefore, property owners are encouraged to install cameras and, where possible, take pictures of such animal behavior on their property. A verbal warning alone is not considered proper notice. Same goes for a goat run out in the road and damaged car. Absolutely. Absolutely. Where an animal or animals without permission enters a property for the first or second time, either the property owner or animal owner may direct the animal in any way to vacate the property. Where an animal or animals without permission continuously enters property, whether or not unattended, such act is considered deliberate, unprovoked, reckless, and a violation of property rights and subject to fair compensation for such unauthorized entry. Now this is important, because people will have all kind of animals. Goat, pig, cow, donkey, whatever. And they do, whether the animal have rope or not, proper care is not taken to ensure the animal does not roam. And when the animal reach from people property, some people want to be bad man or bad woman or whatever the case may be, and acting as though the property rights of other people are not to be respected. Right? Some go as far as saying, so what if they name down little something? Or what that? We have to have protection against that. Right? Where an animal enters property without permission and causes damage, the owner of such property may capture or lock in such animal. Sustained. If the owner of the animal refuses to pay for the damage within 30 days after notice given to the animal owner, the property owner is now deemed owner as of right and may sell or slaughter such animal as of right without further contention with the animal's previous owner. This will settle a lot of cases where you have animals roaming about. If somebody don't want to pay for the animal, them have 30 days. If the 30 day come and then continue not to pay, that animal now becomes property of the property owner. Animals trespassing on property and causing damage, bearing no identifying marks, tag, or label, will be deemed a wild animal without an owner, regardless of whether someone claims to be the owner at a later time. In such cases, the property owner may sell or slaughter such animals as deemed necessary to cover damages or get rid of the animal to his pleasure. Because some people slick. So if the animal does not have any identifying marks or any kind of tag or label, that animal, if it comes onto somebody's property, is deemed to be a wild animal. It does not have an owner. 6. No property owner may be held liable on account of any action taken in relation to any animal which is proven to have caused property damage. So if you have an animal and the animal got damaged somebody's property, if you do not compensate for that damage, you cannot sue that person in court for that animal. That case will never prevail. Enforcement. Violations of this article shall be subject to legal action. Courts shall provide timely remedy, including removal of trespassers, compensation for damage, orders preventing further interference. Limitations. Entry onto property without consent may occur only where authorized by law or necessary to prevent immediate danger to life or safety. Such entry must be limited in scope and duration and remain subject to review. Right? And that fixes the animal problem. If you are traveling on a road and one animal run out in the road and your car or your vehicle get damaged, you have all right to claim compensation for that damage. You can pick up the animal and go sell it. You can carry it, go slaughter it, whatever the case may be. If the owner is not available and you have damage, provable damage to your property, I feel them problem that. Why is the animal roaming in the first place? You're supposed to have complete control of your animal. The animal is an extension of the individual. Right? So, if we have something like this, we get out of the colonial era foolishness. Right? And give people direct action that they can take. You don't have to bring every single thing to court. There are remedies that can be had outside of court. Right? And it don't have to take months or years. So, we have Nick Roy Gale. I'm going to bring you up. I don't know if you still want to come up or if that was a fat finger. Alright, look like you're gone. So those were the new sections that was added. We have a few more sections to go. Again, it seems lengthy, but it is because of the spacing and the full pages that are being incorporated and the font. So the words are enlarged so that we don't have to be squinting to read anything, right? So again, the point of the Constitution is to have a single document that we can look to and say, okay, here is the law on system of law and justice. Here is the law on record keeping. We should have a single point where we can locate the full body of law. We're not supposed to go over this and over this or try find this or try find that. One single location. Right? So, where is the... When we talk about independence, right? And separation of the arms of government, the enforcement of rights, and the accountability and transparency within government function. We have to limit everything to we the people. All decisions that are made has to come from the assent of the people. That is the only way we can protect ourselves. Because if we give up our power, if we give up enough power where the government becomes autonomous, where it is working on its own, we have lived through that already. We are living through it now. If we are still paying taxes, where would it go? It would go into our public treasury system. Right? It would simply go into our public treasury system, and that is where everything would be secured, or we would have expenses drawn from that. And then once we have the accountability, we can see for sure how much money we really have, what is really going on, right? Give me 1 second, I'll be right back. Yeah. So, you know, I want to share something that I came across earlier. I'm going to show you something. Because sometimes we never realize how bad things are. Take a listen.
Well, help me, Auditor General, if I'm wrong.
All right, so my understanding, Mr. Chairman, as the procurement director said, in 2021 they were invited to participate in the training.
Well, I can't hear it.
How to use the system. The circular did not come into being until 2023, but the requirement, the mandatory upload of all procurement came in 2023. So in 2021, the UHWI participated in the training and they took the initiative. They were not required to upload to GoGem. They took the initiative to upload and so that they would start with procurements at $10 million and above. What they failed to do was actually in 2023, and I can't speak to about their knowledge of the circular, but I know that they received training at some point in time in terms of how to use the system. They never went back and adjusted the policy that they had implemented. So they never transitioned from the pilot into and to regularize the adoption of the requirements of the ministry.
I hear you.
But I think they were doing it ad hoc. That's what we saw. They were just doing it ad hoc because they did not embed it in their control and governance process, which is what needs to be done.
That is correct.
All right, thank you. Again, so your follow-up is to provide for us a report once you get the facts as to the 780 transactions that were not uploaded, what size those were, and why those were not uploaded.
Okay, Chairman.
All right. All right, I'm going to key finding 3, which must be the most egregious of them. So somebody help me explain this one. The absence of procurement documentation. The University Hospital at the West Indies could not provide procurement documentation for 51 contracts. However, since then, 28 files valued at 269 million have been found, which means that we can find 22 and one is incomplete. So, and that the 22 that can be found is 246 million and one incomplete is 18 million. So again, just explain to us as a committee, when a procurement is completed, what is the process to put that document, whether it's physical storage, online on a server? Just explain that process to me. Because this, when I'm starting with the acting CEO and you can delegate, but this one to me is the worst one. That you just can't find documents. Even after the Auditor General has been in, you have found about half of them. And obviously you've been looking for the rest and you can't find them. So help us, Mr. Hossein.
Member asked where were they. When I took up the position, I insisted that they must find them. And they were able to locate the 28, and then after submitting those 28, they found one more, maybe 29. They have so far been unable to locate anymore. They were in storage, in a story room, but it was never provided to the auditors. When they came, even after requesting it, they did not provide it to them. But I insisted that they should. I don't think there was, I wasn't there, so I can't tell you whether it was resistance or what, member. It could have been, not lack of diligence and searching and insistence, but they were able to locate some. The search continues, but it is so far not proven any further success other than the 29.
So, I wanted you to hear some parts of this thing here before I interject, But I want to make sure you have it in your head, the context of what is being discussed. This is the Auditor General. These people are supposed to go into places and go find records and go look them over and figure out whether or not the records are accurate. What they are discussing is the inability to find paper records. And those paper records for procurement contracts, which is basically bids for contracts and what was essentially paid out in excess of how much? 200 million. Right? So they're trying to figure out where the 200 million go based on these contracts. Which, anyways, I want to go and listen.
So what is the standard operating procedure, I love this term, for when a procurement is complete, where those documents should be stored, clearly for audit purposes, for both internal and your external auditor, you have to keep your documentation, where those documents should be held, etc. What is that procedure?
I'll ask Mr. Buffy just to share with the
Yes.
meeting. Yeah.
Turn on back your mic.
Yes, Chair. The standard operating procedure is that each document procurement activity is filed in a file folder and placed in a hard binder and then transferred to a storage area where it can be retrieved. Upon my return to the unit, I realized that this practice wasn't being followed. Hence, the reason why these files could not be located. And
so where would those files have been?
those files should have been in a storage area. And my understanding is that that area was flooded at least twice or three times based on heavy rainfall. That was my understanding.
Can you be more specific? Was that what were the dates of? Let me tell you. You know why this one is more serious? We don't know whether you're not even in a position to make an assessment. And I don't want to conclude that it is deliberate, because I don't know. But given everything that we have seen, you could infer that. But to say there were 3 cases of flooding, when were those 3 cases of flooding? Because the first time we're hearing that. I don't know if that was shared with the Auditor General's department. And if you are storing files in a place that flood out easy, you not move it somewhere else, if that is the case? But help me on that one. Because tell me when those flooding took place and whether those were reported to the board, to the internal audit committee, etc. Was there a request for removal to a different storage area? I need to know that. Well, let me ask him. Go ahead. So the three flooding out. Tell me when those took place. No, he said there were 3 cases of flooding. No, but help us here.
Okay, so that was my understanding that the area was flooded.
When?
I didn't get the specific. I'm not aware of the specific. But while I was not there, I understand that the area was flooded.
No, so all right. Is there anybody who can? Because this is the first. This was reported to the Auditor General when she did her review. So it's the first time we're hearing this issue about flooding. So I would like, as part of your report, to tell us specifically when the flooding took place and when those incidents took place, whether management was informed, whether a corrective thing was put in place, whether it's flooding from the roof, the floor, whatever, to mitigate against that. we could never accept that 50% of documents valuing $280 million can be found because of flooding. Because of flooding. I mean, you haven't even assessed the ones you have found yet to determine whether they follow proper procedure.
But if there was flooding, how come they found some?
Well, we need help. Who can help us with that? Internal auditor? You can help us with that? Because, yes, some were found. 28 were found. So it must be from the same era of flood out, where you find the 28. So why can't the other 22 be found? Mr. Internal Auditor, help us here. Again, in conducting, you have to release your mic so I can turn on this. In conducting your intern, is that an issue which you identified and brought to the attention of the audit committee of the board or the CEO?
Thank you, Chair. Just for context.
Go ahead.
Thank you, Chair. Just for context. The internal audit function had done 6 reviews of procurement section. And the issue of documentation not being found is institutionalized. It is systemic. We have done review of it and on several occasions we asked them to put in systems in place to mitigate against that. And it is in the internal audit reports, and since recently they have done something about it in terms of.
So when I hear say it is a systemic issue, not just this current investigation. Anyways,
the management has put something in place and we have reviewed that.
What has management put in place?
They have put in, as the senior director had said, a filing cabinet.
A filing cabinet?
And hard folders. We had looked at them just recently, Chair, right? But it has been institutionalized over a long period of time, and we have reviewed them and reported them to the audit committee, and that is where it ends.
No, hold on. Help me again, because you are saying people put in place filing cabinet.
Yes, Chair.
Me have that in my yard, you know. Me have that in my yard. You can't tell me that the University Hospital at West Indies that spent billions of taxpayers' money just put in place filing cabinet?
Yes, Chair. Yes, Chair. Filing cabinets and hard folders.
Cabinets and hard folders?
Yes, Chair.
So what existed before?
Right. So, Chair, those recent procurement activity, the board, which is the audit committee, had asked the internal audit function to review audit, read the issue of GoJet for the period October 2025 to December 2025. And they have asked that the function reviews whether the procurement department is conforming to the GoJet requirement. We have reviewed it and asked what system they have put in place to mitigate that issue that the Auditor General had identified in terms of record keeping. And they had indicated in their response that they had put in filing cabinets and hard folders, and those procurement activities are stored in hard folders and filing cabinets. And we have reviewed them and confirmed that that is so, Chair.
So let me ask you, the files with your miss, them walk out of the hospital and go on Mona Road? No, seriously, help me. How can those, first we hear rainfall and we took some files, right? And I would like that report, right? Formally. But how can so many files be missing? Somebody take them out of the hospital and go somewhere with them?
Just to say, Chair, in terms of the flooding, in one of our reviews, I think in 2020, that the internal audit reviewed, don't hold me to that, I have to go back in the report, but they did mention, management did mention that there was an area flooded, and they couldn't find some of the files. I did remember that in one of the reviews, Chair.
But if it is one thing to say the file, then wet up, you know. May I understand if you tell me say the file, then wet up. But if you tell me say you can't find the files, that should be it. So before the filing cabinets, which seem to be a great innovation of 2026 to put things in filing cabinet, where were these things being stored before?
As the Senior Director of Public Procurement said, Chair, they were in a storeroom. And just
what kind of storeroom?
Just in a holding area where they would store.
Like the shed at the back of my yard when I put my lawnmower in?
No, Chair, in the procurement unit, Chair.
Listen, people are watching, you know, and people are think that joke business is, you know. No, people really think it's a joke thing that we can be saying in 2026 that institution that spends billions of dollars just putting in filing cabinet and file jacket, and you are storing these in a holding area that flood out 3 times, and nobody is held accountable. And you don't need to be, listen, nobody needs to be a procurement specialist, an accounting professional, if you know that that is basic. I would like to report on that formally to be brought back to the committee, because I can't accept it. I cannot accept that in this day and age, this is where we're at. Cannot accept that. And I don't have enough evidence to conclude that this is deliberate, and I won't say it. But it is hard not to come to that conclusion. That files, so you have the Auditor General do a report, you search hard, high and low, up and down, and it's only 50% of the file that you can find? If you tell me, so then wait up and have to dry. I thought we were now in the age where we were moving things.
Now, now that you have heard from the House of Parliament, and this is just one of many instances, right, where this same exact thing happens. When them say money missing, when them say they can't find this, they don't know how the money gone and them something there. This is an example of that. Because if you can't find the contract, you can't find how much something was supposed to be, you can't hold nobody accountable. Right? So when we talk about in the constitutional draft a national record system, right? Come on. Something like this is far fleeting. This is not in this day and age. But remember, a matter of fact, let us pull up the law. I'm going to show you why they keep on doing this. We talked about this several times before, you know. We talked about this several times before. I'm going to pull it back up so that we can see why they are doing these things, right? Because some of us may not be aware of why they can get away with it. This is the Constitution, Section 48, where it says Powers and Procedure of Parliament. Section 48(3) says what? No civil or criminal proceedings may be instituted against any member of either house for words spoken before or written in a report to the house of which he is a member or to the committee thereof. Remember, you know, this is a committee. Or to any joint committee of both houses, or by reason of any matter or thing brought by him therein by petition, bill, resolution, motion, or otherwise, so they cannot be held liable. It specifically states, no matter what them say in a parliament, they cannot be held civil or criminally responsible. Right? So that is why we have this runaround and this foolishness about filing cabinet. In 2026, when we not only have computers, a matter of fact, the phone them, we now have phones that can operate as a computer. We no longer have just computer. We have laptops. We have so much different types of storage and record systems. The idea that we still are storing things by a file cabinet can only mean one thing. And I am sure many of you can surmise the same. Why I tell you, when them say wickedness can't done, wickedness can't done. I bet you if I did feed them money, then find it. If it was their money at stake and they had to account for it. All right, since they can't find the paperwork, how comes they can't find the other paperwork for the personnel them and the paperwork them for pay everybody every month and them something? How come they can't find them paperwork there? But the paperwork for the procurement, they can't find them. They have flooding. They don't have no copy. It was not uploaded. There is no digital system. Ricardo.
Yes. Evening, everyone.
Evening, Lawful.
Yes, sir, brother. So, it's funny. It's funny because at the end of the day, I remember when I was very young. I'm still young, but toddler. And when these things came on, because they were public, and every time they came on, not even the adults went and watched these proceedings. Whether they're talking about the budget, because the language that they were talking about, it was above us because we didn't understand.
Mm-hmm.
Right? And even up to today, still people try to go on and try to listen. And yes, them understand, say yes, them are steal and them are rob us right in front of our eyes. But we don't know how or what we do. We just like ball and a complain. So now when these things are in place now, when we're putting these stuff in place, it really gonna help us, and you know, this should put that fire and drive in us to say, hey, we really need to stand behind this and get this thing done, rather than just fall off. Because this is happening right in front of our eyes right now, in plain English.
Right.
The wording is not above us anymore. We're learned now. So it's in plain English. It's being said in front of our eyes that we lost the contract. Why then can't go to the original place we got the contract from to get the paperwork?
Well, I mean, that is another problem in itself, because even if somebody have a copy, you cannot rely on somebody else's copy. You have to have yours, and most likely they have the originals.
So we so I mean we might need to go in a politics then, because this
No,
is
no, no,
ridiculous.
no.
If
We're
this
not
just
talking over yourself. No,
oh
sir.
okay,
No.
okay.
We don't want nothing to do with no farmer
No
politics.
problem.
No.
I said my two sentence.
We don't want no unaccounted for funds or unaccountability and them stuff. No. Mm-mm. No, sir. But you know, these are just examples. You know, I just bring up these things to show example of the mind games that are being played and tricking people, because they are showing us all of these things, you know. But if you notice, they are not saying why they can't hold them accountable. You notice?
No, they're not.
They are
They're
telling
just saying
you
that
all of the things
we want
happening.
to work the reports.
Yeah, they might tell you everything happening, but you never hear say they might prosecute them. You never hear say they need to pay penalties.
No.
You never hear say nobody got jail.
No,
You don't hear no accountability. So
No.
what is the point of them talking about it?
not one.
I mean, there is a
And
point.
then he's saying that, oh, you know, we have to be accountable, and you know what you're saying to me no make no sense, and the people are watching and all of this, but there's no, as you said, there's no penalty. So it's like, okay, yeah, they're watching, but what are they gonna do?
Well, there is something we can do, you know, but
I know, but
I am not going to incite anything, especially while we are on our way to bigger and better things. Right? But there are ways to actually hold them accountable. But we're not going to go down that road. We are going to stick to our constitutional draft, because we don't want controversy. We're here for solutions.
Yes.
We don't want a distraction.
That's
We
my two.
fight a battle.
That's my two sentence there.
Yeah, man. All right. Big up yourself. Yeah, so all right. I'm gonna make you listen to the rest of it. It's only how much more minutes? 3 more minutes. I'm make you hear the rest of it. Right?
From physical to electronic records, we scan things, so them depend on a server, etc., etc. I thought that's where we were. That we were not totally dependent on physical files that can get lost, or fire, or water. Have mercy. What? Turn on your thing.
I just want to know, since you mentioned flooding, what kind of system do you have now? Is there a management system where this is stored electronically, or is it that we're still using, still using a filing cabinet and not some sort of a data management system?
That is correct.
That is correct?
That is correct. It's
And
still a
this is
manual
2026, so this is still a manual
It's
kind
still a
of
manual
thing.
system.
You know, Chair, we talk about productivity and the lack of productivity. And this is exactly one of the reasons why we're not moving this country. Because the lack of will. And the fact that you mentioned persons not being held accountable. If it is that we don't get to a place in Jamaica where we can hire and fire people because of non-accountability, these things will continue where taxpayers' dollars, it's not meant anything. It don't mean nothing. It's taxpayer dollar, so we can just do as we wish. And what I'm hearing today is astounding. I am just in total shock for all the things that I'm listening to, and there is actually more here. We haven't started.
We're only halfway through. But Madam Auditor General, when would you be in a position for the 28 that have been provided for you to do your diligence and then provide a report to us.
Mr. Chairman, that will have to be added to the list. I cannot promise that I'll be able to actually do that review for the next 6 months because we're really inundated at this point.
Okay. So let me ask you, Acting CEO, and Ministry of Finance could help me here. I genuinely thought that even where there were physical documents, there was a process to, scan, upload, digitize them. Is this the case in the majority of ministries, agencies, and departments that procurement files are all physical, all in some storage cabinet that could get wet or fire could burn down, and we would have no way of doing a proper audit of them? Somebody have released the mic so I can turn. Yes, go ahead.
Right. I know that we still keep physical documents, but again, we're going to emphasize the fact that if you use the GoJet system, then that data would always be available.
Available electronically?
Electronically. Right. So there are still some physical files, but we are definitely pushing for the use of GoJet.
Yes, Mr. Hussein.
Yes, Chair. As I've stated, the team made it mandatory that as of March 1, all, even those below the 1.5 million that is optional, all, it is 1 cent, must go on to GoJet. So we do have that information on GoJet, but however, for the ones before, they would not all be on GoJet. And even so, in terms of there will always be some documents that are physical and not every single piece on GoJet. But all relevant and important pieces would be on GoJet.
All right. I'm going to have a long meeting. I was going to...
Me say me no want to stop it, because only a few seconds left. You hear what the man say? Not every piece of information is going to be uploaded to their digital system. Only the relevant pieces would be up. I'll bring it back a little bit so you can hear what you say. Listen.
And even so, in terms of there will always be some documents that are physical and not every single piece on GoJet. But all relevant and important pieces would be on GoJet.
All right. I'm going to have a long meeting. I was going to take... No. I'm going to take 2 minutes for a break, and we're coming back. We're done Parliament, so I'm coming back. All right, so if you need to stretch or water or go to the bathroom.
So, on here though, even though they are there identifying the problems that they are faced with, regardless of how bad it is, the man clearly state that not all documentation is going to be uploaded. Boy, I don't know if I tell you, but that does not sound good to me. That sounds like an intentional, deliberate plan of action. You want to tell me, say, from 1962 until now, then just a find out your filing cabinet, did they? Think about it. From 1962, when they reformed Parliament, well, it appears it appears funny, but again, they get away with this because it is encoded in law. They cannot hold their one another accountable. So all they are doing is this. They are making it known. So you can't say them never come out and tell we about it. Exactly, they act like they are investigating, but they are not. How are you? All right. You see, this is why we have certain provisions in the constitutional draft, This is a teaching moment. In the constitutional draft, we say the investigatory agency that is doing auditing, you're not going to ask nobody for nothing. If you can't find it, you can't find it. Because there are going to be definite things in place. If an institution is not following the rules, you simply get penalized under law. You're not supposed to ask nobody for records. What is how does this make sense? You're an auditor and you are going to ask, where are these records? Where are those records? Those things are supposed to be mandated by law or by rule. Standard operating procedures. Nobody not supposed to have nothing under them desk or in a one different room, or in a the cellar downstairs somewhere. But hey, I am not here to tell anybody how to do whatever it is that they are doing. But at the end of the day, it is up to those who have eyes to see and ears to hear. Because none of that I heard a while ago make any sense. In this day and age, every single piece of public record system, well, I can't even say Parliament is public because you can't just walk up in there. You need an invitation. Or you need an escort. So maybe it is not public. Right? But they make this information public. They make the information public. And all people do is say, look at it. Look at what they are doing. Because they don't know how to hold these people accountable. Now, again, I am not here to steer the well. I am not going to be giving out I am not going to be telling people how to go out there and as I can say, storm the fences. Right? But there are procedures out there that can basically stir up the antsness. Right? Make all of them run out. But that is not what we are here to do. We are here to just leave that system and create something that the people can benefit from. That is the point. We are not here to create controversy. Right. Me and my friend then go, well, hey, because they know people are not going to be able to figure this out to hold them accountable. People are not. I mean, if people could, that you see, that is the thinking, you know. You see, sometimes you will have people in positions of power, and over time they realize nobody now figure it out. Nobody now connect the dots. Nobody is finding a way to get to them. So they figure nobody now know them something. Yeah? Nobody now go figure it, and even if somebody figure it out, we have them in our clutches. So what am I gonna do, right? So they don't expect anybody to do anything. But trust and believe, there are people out there who know exactly how to hold them accountable. Okay? And it is not really difficult. It is just that the information is not in one place. And that is why they get away with it. The information is in multiple places. And you need to consolidate all of them in order to be able to do that. But again, I am not I am not going to reveal such information here. Right? The point here is to see that without a public record system where nothing can happen without public accessible records. It doesn't matter if it's a contract, it doesn't matter if it's whatever. I could have just one proposal. It has to be a part of the public record system, which is digital. Paper is only the start of any process. Once you sign off on paperwork, it is uploaded. It's that simple. Every single stage of procurement or contracts and these kind of things should be in a public record system. You can't have hundreds of millions of dollars unaccounted for. Unaccounted for. Anyways, we're not going to rabbit hole here, right? But like I said, we're almost done with constitutional draft. I just want to make sure that we include as much as we need to, right? All of the policies and procedures. The next thing that is going to be implemented is the time frames for dealing with court matters, right? Both civil and criminal. Also the rules of procedure for the special court, the special people's court, where if a public official is to be tried for whatever reason, it will not be by a public official, it will not be by a judge, it would be by the people, members of the public that are not elected. So that way, we have a complete balance of accountability, right? So, have a few more to go. Exactly. Tribunals, no longer will we have a system where you have one judge deciding a matter. It will always be a system of 3 or more judges to decide matters. So that way, we cannot, it will be very difficult to have any kind of bias when you have a tribunal determining matters, right? So that is the system of law we need to implement, put in place, and start having actual justice. Exactly, less corruption. Yeah, so that is it for tonight. We're going to continue on Wednesday. We're almost finished, but we still need to clean up the document and the table of contents. I was trying to keep it at 1 page, but it's going to be extended to 2 pages. So we have to include everything that is necessary to protect everybody, not just those who think they are sitting in a high seat. All right, big up on yourself. Lawful, always.